Hello, thank you very much for joining the eighth talk of the International Speaker Series on Rethinking Cultural Constructions of Law in East Asia. I'm Li Chen, Associate Professor of Chinese Law and History at the University of Toronto in Canada. It's wonderful to see many of you returning to this series. And as many of you know, this series has been co-organized by Professor Taisu Zhang and myself. It was started as a year-long initiative, but we, given the strong interest and also positive feedback, so far we are thinking of extending this year-long series into a multiple year-long project. So please stay tuned and mark your calendar for future talks. In that regard, I also, before I introduce the speaker, I also would like to announce the next talk, which has been scheduled for April 23rd. It will be about the legal professionals and professional community in late imperial China. So a topic that is very much related to what we are going to hear today here. And I will be the speaker. So if you are interested in the topic, please mark your calendar too. It's our great pleasure to introduce the speaker and commentators today. Our distinguished speaker for today's talk is Professor Rachel Stern. Her topic is entitled State Adjacent Lawyers, How Chinese Lawyers Participate in Political Life. Professor Rachel Stern is currently a professor of law and political science at the University of California at Berkeley. And she is also the Pamela Fong and Family Distinguished Chair in China Studies at UC Berkeley. Her research looks at law in China, especially the relationship between legal institution building and the political space and professionalization. She published her monograph entitled Environmental Litigation in China, a Study in Political Ambivalence in 2013. And she has also published numerous articles on legal mobilization and lawyers in contemporary China. Professor Stern is currently part of a collaborative effort to analyze the 60+ million Chinese judicial decisions that have been made available online following a 2014 policy change. This massive expansion in the public record of Chinese court activities promises to reshape our understanding of Chinese law and beyond. Before joining Berkeley Law and the Jurisprudence and Social Policy program, Professor Stern was a junior fellow at the Harvard University Society of Fellows. She also currently serves as series editor of the Law and Society series at the Cambridge University Press. Welcome. We also have two accomplished scholars as commentators for today's talk. I would like to invite Professor Taisu Zhang to introduce the two commentators. Taisu?
We're fortunate to have two excellent commentators, very distinguished commentators with us today. The first is Isa Ding, who is assistant professor of political science at the University of Pittsburgh with a courtesy appointment in public policy at the Graduate School of Public and International Affairs. Isa's research uses a combination of qualitative and quantitative methods to understand two political problems that are becoming more challenging and consequential than ever. Environmental politics and policy, and the politics of autocracy and democracy. Specifically, she's published on topics including democratic backsliding, populism, nationalism, environmental governance, climate change, and legal institutions. The second commentator is William Hurst, who is Chung Hua Professor of Chinese Development at the Department of Politics and International Studies at the University of Cambridge. He works on labor politics, contentious politics, political economy, and the politics of law and legal institutions, principally in China and Indonesia. Among his many publications, too many to list, is a recently published monograph entitled Ruling Before the Law, The Politics of Legal Regimes in China and Indonesia, Cambridge University Press, 2018. So thank you and welcome, Isa and Bill. So before we start, let me just remind everyone of the format that we always follow, which is that the speaker, Rachel, has basically however long she wants, usually something in the range of 40 to 50 minutes to speak and lay out the argument. After that, the two commentators come in with their questions and comments. Rachel has a chance after that to respond to them. And then after that, we go to the open queue, which again will be done by the raise hands function on Zoom. I will moderate the queue. If you find yourself having trouble raising hands, send me a private message in the chat box, or simply type your question publicly in the chat box, and we will also ask those and call on those as we see them. All right, so Rachel, the floors are yours.
Thank you. Thank you so much. Good morning, everybody. You guys will have the joy of watching dawn come to my office here. I'm going to share my screen. I'm presenting an article. I'm going to try to, I think it's going to be more like half an hour. I'll present it and then look forward to the discussion and hearing what the commentators thought about it. So maybe the most important thing, this article is co-authored with Lawrence Liu, who's a Berkeley JSP PhD student and also a JD student at Yale Law. He got up early too, so he's on the call and he'll join in for the Q&A. This piece is also out in China Quarterly. It's out in early view. So if you want, here's the link where you can read it. So the overarching big theme is we're interested in what political participation looks like outside democracies. So in political science writ large, the conventional wisdom would be no elections means no democracies. I think for a long time, those of us who study China have known that this conventional wisdom is wrong. So we're part of, I would say, the mainstream in China studies, following Tianjian Shi's book, Political Participation in Beijing, the well-known 1997 book. We define political participation as actions by private citizens aimed at influencing government policy. And our focus is particularly on lawyers. This is one of a series of papers on lawyers that I've written in the last 5 years. And lawyers, as they fit into the law and society literatures, the emphasis is on lawyers as political actors. And there's a tradition of work in that literature on lawyers as agitators for political liberalism. When it comes to lawyers in China, as I suspect many of you on the call today know, there's been a huge amount of attention rightfully paid, both in the press and in academic writing, about China's activist lawyers who are using law and litigation to push along causes as diverse as labor rights, constitutional review, and even human rights. And in recent years, much of the coverage, again, both in the press and also in academic writing, has been about the crackdown on rights lawyers under Xi Jinping. Beyond that liberal, politically active fringe, we know less about the different corners and types of lawyers in the Chinese bar. I'd say that the conventional wisdom when we started working on this piece was that most lawyers are interested in hustling and making money rather than participating in politics. And that conventional wisdom is informed very much by work by both Ethan Michelson and Sida Liu. So we are just trying to illuminate or shed a flashlight, or I think I've mixed up my metaphors already, whatever, shed some light on a different segment of the bar. And so we're focusing on what we call state-adjacent lawyers who devote significant volunteer time to helping the state govern effectively. So there's two goals here. One goal is empirical. We're trying to develop a fuller picture of the spectrum of Chinese lawyering and answer calls to treat the profession as variegated rather than monolithic. And then the conceptual part is we're interested in the idea of state adjacency. We call it a liminal space between state and society. So it's a boundary spanning position that's neither entirely within the system nor entirely outside the system. And these lawyers that we're talking about, they're serving as citizen partners in governance. On the one hand, they have very strong ties to officials, to the government. They're what we would call politically embedded, but they also have autonomy, or at least a plausible distance from the state. So this is a piece that is about go-betweens or intermediaries that facilitate interactions between two worlds. How do we do it? Let me give you here's the method slide. So we focus on just one group of lawyers with very close ties to the state. We look at lawyers who received the All China Lawyers Association, the ACLA Outstanding Lawyers Award. This is surely not every state adjacent lawyer in China. Absolutely not. But we're confident that pretty much everyone in this sample is playing a state-endorsed political role. And then with help from RAs, we put together a biographical database looking at who are these lawyers. It was 604 at the time that we were conducting the research. And then mostly Lawrence did the interviews with the lawyers mostly in Chengdu and Beijing. Those cities. Just a quick comparison, Chengdu and Beijing. We wanted a first-tier city and a second-tier Chinese city. And I'll just note that per capita GDP is twice as high in Beijing, and it has 2.5 times as many lawyers per capita. So looking at lawyers in two different urban contexts. I think to understand who we're looking at and the role they play, it's pretty important to understand how this award works and how these lawyers are picked. So just to refresh your memory, I'm not sure how many people we have on the call who perhaps study other parts of East Asia. The existence of a private bar in China is relatively recent. It goes back to about the turn of the 21st century. And the government very much remains actively involved in lawyers' professional lives, partly through the All China Lawyers Association, which is the National Bar Association. That the All China Lawyers Association has quite close ties to the state. And you can see that in a number of ways, but one place you can see it is in the ACLA Charter, which makes clear that the organization should support the leadership of the party. That's Article 3. And also that the Bar Association is formally overseen by the Ministry of Justice. So the way this Bar Association award works is that provincial bar associations are given a quota of awards, and then they put together a selection committee to find the most outstanding lawyers. And that selection committee typically formally includes state officials. And we're looking at, there's a fair amount of information publicly available in public documents from different parts of China, and that's what we're drawing on and talking about this. One of the documents we found is a score sheet, scoring lawyers to figure out who should win the award. And that score sheet gives extra points to those who have close ties to the state. Maybe they've served as legal advisors, maybe they've held leadership positions in the Bar Association, maybe they're part of the People's Congress or the Political Consultative Conference. So local justice officials are involved in the selection process, and the documents detail the expectation that the winners will exhibit excellent political quality, exceptional professional integrity, and outstanding work achievements. So let's get into the empirics. Who wins this award? Here's our summary chart. And here's the summary sentence that goes with the summary chart. The average outstanding lawyer is a well-read, domestically educated man working in private practice with strong ties to the National Bar Association or his local bar association. This lawyer is, from what we can tell, is more likely to be a party member than the average lawyer in the lawyer population as a whole. So we're looking at information from Beijing and Shanghai, where we have information about the number of lawyers who are party members in those cities. So I'll just give you the numbers for Beijing. In Beijing, it's 32% party members in the bar as a whole versus 69% of outstanding lawyers who are based in Beijing. When we did the interviews, it's always nice to know when people were surprised by their own research project. This is what surprised us about our own research project. When we talked to lawyers, we asked them to estimate how much of their time they spend on voluntary activities. And we were surprised that it reached 40%. And there was huge variation in this as well. But we're surprised that they're spending 40% of their time on voluntary activities, because one of the things we know about the Chinese bar is that Chinese lawyers are still, by and large, paid on an eat what you kill system, where how much money they make is directly related to how much they bill. So this is lawyers, a group of lawyers, not all lawyers, it's this particular group that we're looking at, that are devoting significant volunteer time to what we frame as political participation. We use the interview data to argue that they self-consciously span the state-society boundary and use their professional identity to help the state in two ways. One, with information, and two, with persuasion. Let me talk about the boundary spanning. I realize this is a long quote, but the question that we asked people is we wanted to know if they conceptualize themselves as within the system or outside the system. And as is often the case with qualitative research, what became most interesting is when the interviewees rejected the question, as the majority of them did, just did not like the question. That was just not how they saw themselves. And here's someone who was particularly eloquent in telling us why that totally seemed like the wrong question to them. So here's this person wrestling with this question that we've asked. If we use the phrase within the system and outside the system, all part-time government legal advisors are within the system, but we're also not official government staff members. So we're really both inside and outside. From the within the system perspective, we respect the law and follow the government's lead, and we wholeheartedly serve the government and country when acting as government advisors. But in terms of outside the system, we're not an official part of the establishment. We're not government employees. We provide services on individual issues as they come up. And what we can tell the government is merely suggestive. The government can adopt the suggestions, but they can also reject them. So what are they doing as they straddle within and between the system? One thing that they're doing is they're providing information. So if we go back to Lenin, Lenin had an idea of signals from below. And one of the ways in which China under the Chinese Communist Party as a Leninist state is all of the formal feedback mechanisms that exist to give the state information about what's happening with ordinary people. It's supposed to help the party self-correct, of course, and give the government a window onto social problems that they might not otherwise be able to see. So we see outstanding lawyers, our state adjacent lawyers, providing information in a range of formal and informal channels. In the formal channels, these are the formal roles that they hold, the kind of title you might see on a business card. In fact, many of them do have these roles on their business card. And that's where you share information with the state by design. One of the small surprises in this project is I had not realized how important the role of government legal advisor had become. That's, of course, been a trend in recent years, and there's an official goal of establishing legal advisor positions inside all party and state organs. So I think this is pretty intuitive. You've got the formal channels on one side, semi-formal channels. I mean, pre-COVID, maybe still happening in China. Not sure what the COVID restrictions are, but officials would mix with outstanding lawyers and also potentially with legal academics and others at conferences, workshops, brown bag lunches, and then ranging over to informal channels, shared social circles, dinners, WeChat groups. So in all of these ways, state adjacent lawyers are providing information, sometimes based on their identity as citizens, sometimes about what's going on in their neighborhood, but more frequently about what's happening with the profession. And in particular, if they have a zone of legal expertise within their zone of legal expertise. So just to give you one example, one of the outstanding lawyers we talked to is a trademark expert in Beijing, and he uses his leadership position in the bar to open up a lot of communication with the Ministry of Justice and as he puts it, to teach about and guide the direction of trademark law in China. What about the persuasion part? So this is part of our, it's a small sample, but it's part of our sample. About a fourth of our interviewees discussed the work that they do to try to persuade citizens directly to act reasonably. That's a common phrase. So acting reasonably generally means convincing citizens to moderate their demands, to listen to the government, to pursue legal channels as opposed to extra legal channels. I'll just offer one story as an example. This is from a Beijing lawyer who compared being, it's an interesting analogy, he compared being a lawyer to being a film director. And he was representing two parents whose son had died due to an ice patch on a highway. And the parents blamed the government for not maintaining the highway properly. And they were longtime petitioners. They've been complaining to government about this issue for over 10 years. But this lawyer knew that the petition route was never going to work for them. And so the story that he told is he told a story about how he convinced these parents to give up their fight by addressing their emotional needs. He empathized with them. He said, I'm also a son, and then called on them to envision their son looking down on them from the afterlife, and the son calling on them to give up because it was causing them so much pain. And they did. They gave up their grievance, and the lawyer was recounting this as a success story. Other lawyers who talked about persuasion talked about how they use their professional identity. They talked about how they're trusted to be objective because they're professional, they're douanier, third parties. So, for example, we talked to a Beijing lawyer who represents migrant workers. And if a client disagrees with his approach, he simply says, I'm the professional here. So here, what we see, or the gloss we put on this, is that lawyers are using their professional third-party status to convince very angry citizens to trust them. So here, the lawyer's distance from the state, the fact that they are not state officials, is really helping them. They can step into a role, or potentially step into a role, as a trusted interlocutor between state and society. And from that position, where they have some distance from the state, convince citizens to moderate their demands, or even to, what law and society scholars call, lump it, to give up and go away. One of the questions we're interested in is why? How do we understand this? Why are lawyers willing to devote so much time to this type of political participation? And we went into this with lawyers, and we offer a take on it. I think our starting assumption, at least in political science, would be money or power, that we would look for some kind of self-interest in their activities. And to some extent, this is true. These kinds of ties to the state are certainly associated with status, with building a reputation, and with the ability to charge more. One of the interesting things about this story, or the account that we offer in this paper, is that these lawyers have built up their political embeddedness over time. So political embeddedness, the extent of an individual's ties to the state, that's not our idea. It's been used particularly by Ethan Michelson and others writing about Chinese lawyers for a long time. But one of the things we're adding here is we're pointing out that there's a social mobility part of that concept. These lawyers mostly come from modest backgrounds. This is not a multi-generational family story of wealth. They're able to build up their political embeddedness, their ties to the state, through their volunteer work in their own lifetime, and particularly by volunteering inside the Lawyers Association. So to some extent, of course, having this reputation in this, especially in smaller towns, will help attract clients. It helps with status. It helps with establishing your law firm's reputation. But we don't think it's 100% about money. Oh, and we don't think it's about power either. I should put that part of that piece on the table too. We asked about political efficacy, or perceptions of political efficacy. We asked specifically, can you tell us about a time when your participation in politics made a difference? And very few people were able to recount a specific story of a time when their interventions had changed an outcome. There was one notable story about a lawyer who had offered a policy suggestion to increase jail time and fines for drunk driving and was successful in that quest. But that was kind of the only story that we got out of our interviews that was able to point to a concrete payoff. And in fact, people, if you pushed a little, were quite modest about what they thought they were able to achieve, and some were quite actually disillusioned. And they also suggested that it was not 100% about money. These lawyers were very insistent that they were not the richest lawyers in society, that if you just actually wanted to find the richest lawyers in their city or their town, you'd be looking at a different group. So to be sure, to sum that all up, of course, there's a bump in prestige and status. And that's part of the fun, and for some people, part of the point. Lawrence has good stories about lawyers who wanted to show off selfies of themselves with Xi Jinping. But where we ended up on this, and this is a place where I think different people might reasonably come to different interpretations of the data, is we took lawyers seriously when they talked about their sense of social responsibility and their willingness to sacrifice themselves for the profession. Actually, people also talked about how they felt a stronger sense of social responsibility after the award, about feeling pressure to live up to the title. And some also talked about a career life cycle. This tends to be an award that you win in the middle of your career or towards the end of your career. And people talked about reaching a certain place in the professional hierarchy and starting to think about giving back. And so this theme of giving back and giving back to society came up in the vast majority of interviews. And we take it seriously as a sign that the state has some true believers, in the sense that there are people who are willing to contribute their time and energy. Well, what is it that they believe in? There are definitely some outstanding lawyers that are party loyalists and will talk about their sense of loyalty to the party. But more common was a sort of more modest discussion of forward progress and perfectibility of the system. So we got a lot of people talking about incremental reform. Things may be far from the ideal, but they're better than they were before. Even if it requires generations of hard work, things will work out well in the end. So in the end, we interpret this political participation as part of a universal desire to do meaningful work and to contribute to a cause that's larger than oneself. Let me start to zoom out here. Of course, the lawyers that we're looking at are not the only groups in Chinese society that are state adjacent. This is an inevitably partial tour of the literature, but I just wanted to highlight some of the other work, really wonderful work that's been done in recent years on other groups that are state adjacent and are doing these two functions, providing information and aiding the state with persuasion. And in particular, I'll call your attention to the article, the Zheng and Hu article that came out in China Information, that's about lawyers directly, and is kind of a companion piece to ours. So there's quite a lot of volunteerism. And I think this is part of a long-standing pattern in state-society relations, where the state relies heavily on cooperation from the well-to-do classes. I'll leave it to the historians to chime in the Q&A, but it reminds me at least of imperial China and the reliance on the gentry. And then in the more modern period, Mao's mass line, the reform era's reliance on policy advice from technocrats. This is a place with a long history of citizen consultation. I think it cues up, this article cues up comparative questions about state adjacent go-betweens and other moments in Chinese history. And of course, people playing similar roles in other places. So I'm going to punt on that a little bit and leave that to the discussion in the Q&A, and hope that many of you have examples to offer and can help complicate this account. But I did want to comment on culture. I'm curious what's happened to culture over the course of the series. I'm totally uncomfortable talking about culture. It's, I think, a product of my political science training. Much more comfortable talking about history and institutions. But of course, different societies do politics differently. That's just a starting point. What I see here in this case is some things that are distinctively Chinese, and I'm going to frame it again in terms of history and institutions. China, under the party, has had a long history of this kind of award going to different kinds of model workers. So that's a long-standing historical legacy. And I've already suggested that there's a long tradition of reliance on political elites to participate in politics through a kind of indirect rule. So I think that's all building on long-standing political legacies in China. But there's a kind of a global story here as well. And I think what's interesting is the rise of lawyers as a professional class in China is very much part of global trends. And so what we have in the background of this paper is a global story about the cachet of professionalism. And who does the state turn to in this period? This period being the contemporary period, the 21st century, as a trusted citizen partner in governance. It's professionals. It's the lawyers that we're profiling, but also, as others have written about, social workers, journalists, and others. And it's also intersecting a global story about the rise of the rule of law in authoritarian legal systems. So it's intersecting, it's this story about increased reliance on legal advice in particular for the Chinese state. This is pushing just a little bit beyond where we go in the paper, but one way to look at this would be to see these lawyers as brokers who one by one are training citizens away from the politics of supplication. So that's would be one way to think about petitioning is an individualized politics of supplication towards a Weberian rules-based bureaucracy, towards encouraging them to use the legal system and to accept the rules and limits of Weberian bureaucratic rationality. Let me offer three different implications. The first is that if you follow me in treating these lawyers as brokers, they're not using their political connections exclusively for personal gain as they would in a patronage model of politics. So we're arguing that they're very real political participations. This is a meaningful form of political participation, that of course they're human, they're motivated by status, but also by a desire to contribute to something real. A second layer of implication is I'm going to go back to Dahl's classic question of who governs. Who is it? Who are these people? And so this brings us to a point about inequality in political participation, which I realize is a very contemporary American thing to be thinking about. But I think it's also worth noticing, and this is just the biographical characteristics of the participants, that some people are more likely to be recruited into these roles than others. This is a channel of political participation that is really dominated by middle-aged Chinese men. And then third, I think that these lawyers and other professionals who are playing the state-adjacent role are part of what you might call the micro foundations of authoritarian resilience. Or to put that in plainer English, I think they're really helpful to the state. I think they're giving the state a huge boost. So that this is an old point in politics, but formal institutions moderate participation so that dissatisfaction stays constructive and within the system. These lawyers are doing that. And of course, there's a point here about the politics of cool as well. The state can attract these types of volunteers. It has not had any trouble attracting these types of volunteers. And a state that's in trouble is one where nobody wants the symbolic capital that it has to offer. But we're not there yet in China. They just announced a new round of these awards in September of 2020. We haven't coded them up, but that would be an obvious way to extend this project. All right, thank you. I will leave it there.
All right, thank you so much, Rachel. Next we have the commentators. So we're gonna go in the order of Isa and Bill. And so Isa.
Thank you. Thank you so much, Rachel, for sharing this interesting research with us. And thanks to the organizers for giving me this opportunity to pose my questions and share my thoughts. And I want to start off my remarks by saying that I love everything that complicates conventional wisdom. So I very much enjoy reading this piece. You and your co-author point out that politics is not always a story of neatly divided antagonists with representatives of the state on one side and members of the popular classes on the other side. You argue that state-society dichotomy is problematic, and you introduce this in-between zone, which you call state adjacency, arguing that state-adjacent lawyers serve as a bridge between the state and the public, and between the state and the legal profession. I also really appreciate that you show the agency of these actors, this notion of voluntarism. You demonstrate how these lawyers volunteer in underscoring this non-material satisfaction of civic-minded political participation in China. And looking at the interview data presented in this paper, there seems to be at least 3 different interpretations of the power relations between these lawyers and the state. So first, the state is outsourcing these tasks to trusted individuals, including the demobilization of citizens. And second, lawyers are seeking opportunities with the state. However, these opportunities are not primarily material benefits, at least according to the lawyers themselves. And third, state and society come together in this corporatist way to solve concrete problems. And you argue that these are not mutually exclusive reasons, and this is a symbiotic relationship. So I find that compelling. I also see parallels between this study and some recent research on Chinese NGOs. I will ask 2 questions, which this article inspired me to think about, and it might be beyond the scope of this particular project because it's already being published. And so those are just questions that it made me think. Sorry?
It's okay. I think it's somebody just.
Oh, okay. So the first question is about the meaning of work. The way you talk about these lawyers is refreshing. So they're not just driven by money or access. And I want to know how the lawyers understand their profession and how they understand the place for law in Chinese politics. So on page 12, you cited examples of lawyers who criticize the lack of judicial independence. So I'd be really interested in hearing about how the lawyers understand the rule of law. Do they have a different understanding? So there has been much research done on how Chinese people understand the notion of democracy, and does that differ from quote unquote Western conceptions of democracy? So I wonder if the Chinese conception of rule of law is also different than what the lawyers' conceptions are in particular. And what is their identity and how they view their identity? Is there any tension in the observation that they're used by the state to demobilize citizens, and then they're driven by an urge to serve society? And so this is perhaps an anthropological question as much as it is a political science question. And I heard more of your thoughts on this in your remarks and your, especially toward the end of your talk. And you talk about the professionals and the rise of the lawyer class. I thought that is really thought-provoking. And furthermore, on the same point, I find your ideal type of state-adjacent lawyer conceptually compelling. And I'm wondering about the rest of them. because not all lawyers who are not state adjacent are the activist type. So is there a qualitative difference between state adjacent lawyers and the average lawyer who's also not an activist? And to what extent is state adjacent lawyer a distinct identity? So that might require some comparison between these lawyers and the rest of them. And so that's my first question about the identity of the lawyers and how they understand their work. My second question is about the notion of state adjacency. You problematize the state-society dichotomy by introducing a gray zone or intermediary zone. I think this is a very helpful corrective. But after reading about your thorough description of these lawyers' relationship with the state, I was curious to hear about their relationship with society. Your examples of political adjacency describe the instances when society and the state come into conflict, and the law is on the side of society, at least the letter of the law. And what about when the law and society come into conflict? So the paper starts with examples of Tan Biao and Chen Guangchen, but when I think about Chinese law, I think of the specific legal cases and not the lawyers themselves. So I think of the Yu Huan case, I think of the Zhang Coco murder case, which stirred up a lot of public opinion polarization in recent years. This is the same way when I think about American law, I think about specific cases such as Roe v. Wade and Loving v. Virginia. So do they have any equivalents in China, and how do complicated power relations play out in these critical cases? And should we be looking at actors per se for sources of tension, or should we be also looking at the substance of specific legal cases? And finally, your way of, and this is my last point, your way of problematizing this received wisdom, the state-society dichotomy, is by saying that we might add gradations, shades of state-society separation, this in-between zone, intermediary zones. I do wonder, though, and I don't know the answer to this question, are there ways that problematize state-society dichotomy that go beyond adding spaces in the middle, but still kind of still conceptualizing them in linear terms? Is there a way of thinking about the relations in China that the way that moves us beyond that, but not just kind of by elongating these dimensions and adding these spaces in between? So that's a thought that's obviously beyond the scope of this research, but definitely what this made me think. And so thanks again for offering this, offering us this very unique window into relations between the state and this fascinating set of Chinese legal professionals. I'm really looking forward to seeing where this research agenda takes you next. Thank you.
All right, thank you very much. And next up is Bill.
Hi, thank you very much for having me. Thank you, Rachel, for a fantastic presentation. I'll keep all of my comments very brief, as I always start from the basic principle that the worst kind of discussant is one who is long-winded. And so, the point at which I'll start is just to say that I think this paper is extraordinarily well put together, very nicely written. It's really exemplary in terms of presenting a whole range of data in a very systematic and thorough, yet clear and non-confusing kind of linear way, right? So I think you're definitely to be commended on putting together a very nicely organized paper. The main question that I have really to sort of encapsulate everything I'm gonna say is how much of this is really something we should be surprised about? And you kind of say several times in the paper, including really prominently in the conclusion, that this is surprising in some way. But I found myself scratching my head kind of wondering, where's the surprise, right? Because for several reasons, right? So let's start with the first. The first is that these are model workers, right? These are people who are winning awards from the CCP for being, sort of labor models to be imitated. In that sense, I don't see why we should expect them necessarily to be fundamentally different from what people going all the way back to Andrew Walder and even his predecessors talked about in any kind of socialist work unit, right? That there are activists who seek the favor of the state and the party committee in order to glean legitimacy or improve their position in other ways. And that appears very much what many of these lawyers are doing. So why do they engage in all of this volunteer activity? Well, why do residence committee cadres in any urban neighborhood do that? Why do model workers in any factory do that, right? I don't think it's terribly confusing or different in this context from what we see in many, many, many contexts over decades throughout China. The second point is these are lawyers after all, right? And lawyers in any society do interact at much closer range with the state than most ordinary people, right? Because the law and the legal system, after all, are always and everywhere fundamental institutions of the state bureaucracy and basic mechanisms for the exercise of certain aspects of state power. And the role of the lawyer, even when they're not working directly in the state, is in some way to facilitate the interaction of citizens with those institutions and with that power, right? Whether that be to call the state in as a sort of tripartite dispute resolution partner, or whether to represent the individual facing down the legitimate violence exercised by the state through criminal law, right? In any of these contexts, the lawyer's role is actually to bring the citizen before the state in some capacity. And so it's not a surprise that we should find lawyers being close to the state. Particularly in the Chinese context, you cited Ethan Michelson's work from some years ago, work of many others, including some who are in the audience and even with their hands raised, talking about how the private bar is a relatively new thing. And yes, if we go back 20 to 30 years, we see lawyers just taking very cautious steps outside the state's embrace, even to work privately and not as state employees. And so in that context, I think it's especially not surprising that we see a lot of lawyers still towing a fairly close line to the state. The third aspect of things that lead me not to be surprised by the closeness of lawyers to the state and by lawyers choosing to play this role is actually what you talked about as lawyers as brokers in this context. And that reminded me a lot of a term that my co-authors and I used in a 2014 article on village petitioning, which was semi-autonomous organizations with mediating capacity. And what we're seeing here really are not so much organizations as individual lawyers, I think, playing precisely the same kind of role, sometimes convincing plaintiffs or potential plaintiffs to lump it, sometimes actually channeling the anger and sort of righteous indignation of the same people into legal action rather than street protests or petitioning, right? And that's exactly what we found, old people's associations and retired teachers doing in various parts of Fujian province and a few other places. What I think is interesting is to extend this and try to see, is this something that lawyers are doing across the board in the Chinese legal system, or is this something confined to more particular contexts? And actually, that's kind of what I'll give as a more sort of final summation question is, to what extent can we extend this, not to be too redundant in terms of diction, but to what degree can we open this up to a broader perspective? So for example, in some of those villages and townships in that one province where we found this pattern holding, we found old people's associations essentially taking over local governments. And so you mentioned that there's only one or two very small kind of examples at the margins in which these lawyers felt they'd actually gained some control over government policy and affected meaningful and substantive change. I wonder if it's not feasible to think that maybe in some contexts, lawyers acting as state legal advisors or officially designated model lawyers or law firms with particularly close ties to the state might actually be able to capture certain important functions of the state bureaucracy in ways that perhaps wouldn't be as obvious. And then the second thing would be, is there a larger perspective we can gain from this on sort of where lawyers are headed? Because I think, as you alluded to a few times, I think there is a general conventional wisdom in the literature that Chinese lawyers are slowly inching away from the state. You know, if we think, again, lawyers in private practice and these sort of private law firms and so on, particularly those involved in civil dispute resolution, who I think are most of the ones you're thinking about here as well, rather than criminal defense lawyers or those going into administrative lawsuits, right? So, you know, we have this general conventional wisdom, I think, out there, but you're suggesting, it seems, that maybe there's a counter movement or a reverse tide that we need to think about. And so if there is, to what extent is that real? And if that is real, to what extent are lawyers or bar associations or lawyers in specific roles potentially able actually to capture those institutions of state power at the micro level? Very last thing I would just mention about what's not surprising. I really don't think it's surprising that party loyalty is key. It is, after all, the first of the three supremes, as sometimes translated, the Sangha Zhishang, right, which I noticed the article did not mention, going all the way back to 2007 during the Hu Jintao era, that were mentioned as the critical elements of successful legal reform, and I believe the second 5-year plan of legal reform. And so, you know, that doctrine seems to establish very clearly that loyalty to the party is absolutely critical for the entire legal system as its foundational guiding principle, even more than the other two. And so, you know, in this context, again, sort of that being a key criterion for selection of model lawyers is not a surprise. But I do wonder, is there a way for sort of a greater advocacy role and a broader statement about lawyers to be gained from this? But a very well put together article and an interesting presentation as well. So thank you very much.
Great, thank you. So just a reminder to the audience, when we open the queue up to the audience, please try to use the raise hands function if you can. Like the typing your question to the chat box thing should be a last resort. If you can't use the raise hands function, don't use that as the default thing, please. So at this stage, we would like to invite Rachel and Lawrence, if he is on the call. I think he is, I just saw him. To possibly respond to the questions and comments that Bill and Isa have raised. And after that, we're going to go to open Q&A.
Thank you. Thank you so much for a really interesting and rich set of reactions and comments. Lawrence, maybe I'll kick off a little bit and then I'll kick it over to you. I hope that's okay. The weirdness of Zoom is I can't see anyone or anything, so I'm going to assume that's okay. A couple there's much more here. I don't want to spend too much time in replying because I want to get into but let me pick up a couple of the themes. Isa, I think so many of your questions, as you suggested, kind of call on us to speculate or to draw on comparisons that aren't in the paper, but that perhaps we know about from other research that we've done. In terms of how lawyers understand their work and the rule of law in Chinese politics, I think it's what I'm interested in about the mainstream lawyer identity, and here I'm not just drawing on the paper, but on dozens and dozens and dozens of interviews with Chinese lawyers over a long period of time, is that I don't think they experience too much of that tension. John Bliss has a new paper out on this in LSI that's a really nice paper comparing young Chinese and American lawyers. And what strikes him in comparative perspective is that young Chinese lawyers don't experience divided selves. So that thing that's so common in American law schools, where lawyers get really stressed because they have to put their public interest self to the side while they do their corporate work. Chinese lawyers, by and large, he finds in his study and what I've seen in both in this paper and in other research, they don't experience that. I mean, I think what's so interesting about the mainstream of the Chinese bar is it offers a kind of very modest hero narrative to ordinary lawyers, that just kind of the everyday work is meaningful because the country's headed in the right direction. There's this incremental kind of reform, and even just the modest work of getting citizens into court or trying to convince corporate clients to follow the law, that's meaningful in terms of China's legal development. So I'm really interested in that set of ideas, which in other papers we've called kind of an attitude of cultivated patience that combines a sense of hope and optimism, and also, looking to the future, a sense of teleology of time, but also an emotional orientation toward the present that I think is really interesting. The other piece that I'll pick up is Bill's comment about whether we should be surprised. I think that's a totally fair reaction to the paper, and I wonder how much of our surprise that we've ginned up in order to sell this paper is the surprise generated by kind of weird priors in the American social science literature. So one weird prior would be that there's no political participation in China. I mean, I think Bill, that that's not true, so that doesn't surprise you. Another weird prior coming out of the influence of economics in the 20th century is that we expect people to only do things because of self-interest. And again, we're pushing back against that narrative as well. But there's a huge amount of historical continuity here. And in some ways, I mean, one fair read on the paper, I think, would be for it to be a paper about historical continuity and historical legacies. And if you know China and you know the context, you know the history, I think that's a fair reaction to be more impressed by the continuity than by any kind of rupture. Lawrence, did you want to pick up any of that?
So I don't have too much to add, and I'm kind of curious to get to the other questions. But I guess one thing I wanted to pick up on that Bill mentioned was kind of this emphasis or this focus on individuals instead of organizations. So I think we recognize that there is a lot of really rich and kind of strong literature on the ways in which organizations have been relied upon by the state to perform a variety of social functions. And I think our contribution to that is by thinking about individuals and thinking about professionals, kind of the ways that they're being brought in and not kind of embedded in a more collective sense. So that's just something else I want to highlight. And it might not be surprising. I think it is definitely a continuation of a lot of things that China scholars already knew about, but then to the extent non-China folks, or even folks who are more focused on the public discourse, might not have recognized otherwise.
All right, so Rachel, like, this was fantastic. Lawrence as well, congratulations on such a, like as Bill said, like polished, well thought out, well-constructed paper. So my question kind of falls up on Bill's last question, which is, let's talk about trends for a second. I noticed you guys don't try to draw kind of like chronological distinctions too strongly in the paper, perhaps because of like the somewhat limited number of people that you can talk to. But there's like I do want to kind of ask, like, what has changed, if anything, in the past, I don't know, 6-7 years since this like Yifat Zhiguo project became a thing? Because, like, intuitively, that's the kind of project that presumably would both encourage the state to create more state-adjacent lawyers and to try to kind of like draw more lawyers into its adjacent folds. And also at the same time, perhaps give more incentives to large amounts of lawyers to work more closely with the state, right? So given that the state seems to be responsive and welcoming to kind of like a legality-oriented mode of operation, pays lip service at least to legal professionalism and things like that. Would this encourage lawyers to be more cooperative and to see more opportunities for personal advancement and career advancement within the kind of like state adjacent dimension than before? And do any of your interviewees mention this kind of like shift or perhaps trend over the past couple of years?
Yeah. Thanks for bringing us back to the trends question. I'm happy to talk to that. If I can just be allowed a brief moment to be depressed about something being outdated as soon as it's published, I just have that emotion. So the second we published this paper, more awards came out. We should really bring it up to date. But it's a lot of work to put together this database. So I mean, that happened afterwards. So I think there's some work to be done in terms of looking at the next batch of awards. And then we mentioned just at the end, there are these party legal awards that are for party members. And so there's some work to be done there too, in trying to figure out if those, I think those awards are going to the same people. We did a little bit of preliminary coding on that last summer. The ones that are specific to the party. But what I see as the big trend here, Bill suggested that the big narrative was that lawyers are slowly inching away from the state, and sort of suggested that one way to read this paper would be about a counter movement or as a reverse tide. I guess I see the trend as the variegation of the Chinese legal profession. I think it's increasingly difficult to talk about a legal profession. I think it's different corners of the legal profession with diverse ideologies, and that you see some of that splitting up of the legal profession in terms of symbolic capital, in terms of where people go for awards and for status. I mean, we're looking at one particular set of lawyers that is perhaps unusually oriented towards the state, but it's a really different world in the corporate law for the red circle law firms of Beijing and of Shanghai, and which I think is oriented towards a different kind of status hierarchy. So the competition among different types of status hierarchies, and I think underneath that, competing notions of what it means to be a legal professional, I think is a trend and is also continues to be worth exploring. Taisu, I was thinking about your paper with Tom as I was talking about the growing importance of legal advisors inside the state. So that is a trend. And so in a sense, these lawyers, the state adjacent lawyers, have more to do under Xi Jinping than they did before. And there's room to develop more of that as well. Lawrence, I feel like this is a chance to talk about your Bree paper too. Which is in many ways a companion piece to this.
Yeah, so I guess on the variegation point, I think something we would need to look into more examples and hopefully kind of get a better sense for change over time. But at least my initial sense is that the state is at least trying to bring in a lot more corners of the profession, spots of the profession that might not have always been seen as obviously state adjacent, as some of the folks here. So I have a separate project that's should be coming out with the Yale Journal of International Law sometime soon that looks at a group of individuals who have been identified as BRI, cross-border legal experts. So this is kind of a different set of people, a group that we might imagine wouldn't be as obviously state adjacent. And I think there are some differences between the way our outstanding lawyers see their role and participate and the way these BRI lawyers do. But I think this state adjacent frame is still quite useful, and also the ways in which the state, at least from a top-down perspective, is really pushing to bring more lawyers on board. And so I think we could expect over time that there will be a lot more opportunities for state adjacent involvement, and there'll be more incentives, and definitely would be interested in seeing how that plays out, both with outstanding lawyers, but also other parts of the legal profession.
So our queue right now is Don, Marianne, Zhang Yang, Li Ling, and You Ziying, I think. So Don, go ahead.
Thank you. Thanks for a great paper, Rachel. So you start out, and Lawrence too, sorry. So you start out by saying that you wanted to look at political participation as something that can occur despite the absence of democratic elections. And so that suggests that you see it as something that involves citizen input into government policy. And I think your definition at the beginning of the presentation, talks about that. But I have to say that as you were as your presentation progressed, I kept on waiting to see something that matched your kind of definition of political participation, but I wasn't seeing it. These lawyers don't seem to have any input into government policy. Certainly not more than any full-time government employee, a totally titre person would have in the appropriate position. You describe them as trusted partners in governance. Their object is to make things easier for the government, and they say themselves, we're 100% loyal to the government. So, if this is what you mean by political participation, okay, nobody can monopolize the definition, and as long as you define it in some clear way, that's fine. But I don't think that's the definition of political participation being used by the conventional wisdom that you're trying to refute. So if the object is to say, hey, look, you can get something similar to the political participation that elections involve, even without elections, I mean, that might be true, but I've got to say, I'm just not seeing it in the evidence that you presented in this paper. Thanks.
Thanks. I think I was moving too fast on. I apologize. I was trying to get a lot in a short period of time. I think that and I think this is kind of a well-known story for folks who study China. The kinds of political participation that we have in mind, I offered an example just in passing of the Beijing trademark lawyer who gets invited to kind of meetings around setting trademark policy. I think the combination of, we call it information provision, but you could also call it input into policymaking, is quite common for these lawyers. And comes up in our interviews. I mean, I think we differentiate between being invited into the process, which almost all the lawyers describe as, particularly when it relates to their area of specialty, and actually having an influence over policy. And that's where they kind of struggled to come up with examples of political efficacy. And they're doing it in different kinds of formal and informal institutions. So the one example of political efficacy that many lawyers in Chengdu wanted to talk about was the lawyer who introduced, I think it was I forget if it was through the People's Congress or the Consultative Congress, but to stiffen the penalties for drunk driving, and that actually ended up in a policy change. But I think it's clear that particularly when it comes to changes in law and policy, that the government is turning to legal experts for advice. And of course, this group of legal experts is the people that they would think of first. Lawrence, did you have an example?
Sorry, can I just add something though? But has the conventional wisdom ever denied that in an authoritarian, even totalitarian society, the government, if there's a pandemic, that they might go ask a doctor who's not in the government, what do you think we should do? I mean, has the conventional wisdom ever denied that authoritarian governments seek advice from experts?
Let me think about that. I mean, I think there's a difference between, a crisis situation and an ordinary routine mode of political participation.
Well, sorry, I didn't mean to.
Yeah, I know. It's
just a crisis situation. I just mean, just generally consulting experts. I'm just not convinced. I'm just not seeing a difference here between what these lawyers are doing, which is basically providing technical advice, and what might occur in any society. And I'm just not sure that the conventional wisdom has ever denied that this sort of thing takes place.
I think I can lump that comment together with Bill's, with this is the "I'm not surprised" reaction, which I think is fair enough. I mean, I think the question is always about to the extent to which the experts are inside the state or not. And you can imagine a situation with a regime where to be trusted, you have to be inside the state. And certainly, actually, this is, if you want to talk about trends, this is the direction that China is heading in trying to bring the lawyers inside the state and create the government lawyers and in-house lawyers. This is a booming growth field. So to the extent that there's a trend, I think it's heading towards bringing the legal expertise completely in-house. And so I think does it happen? Is it common? Probably, but there is something there, but maybe it's just, and again, I don't think we have a monopoly on this idea. I don't think China has a monopoly on this way of governing, but there is something interesting about this group that is, and again, I'm going to emphasize the routine nature, that they're routinely invited into state processes and routinely called upon to mediate between state and citizens without being on the government payroll. Lawrence, can I get you to, did you have anything you want to add?
Yeah, I guess I just wanted to quickly, reemphasize this difference between, political efficacy and political participation, because we didn't see a lot of kind of direct examples of efficacy, but we wouldn't necessarily say then that there's no participation. And also in the paper, we distinguish pretty clearly, between what we would think of as more informal modes of participation to more formal modes. So there are a lot of examples of lawyers who are members of either their local or their provincial or the national consultative conference or the MPC. And so that might be thought of at least as a more formal and kind of obvious route of political participation. But a lot of those stories are about lawyers who have good connections to people in the government, and maybe they invite government officials to their law firms to participate in certain types of conferences. They might host certain meals that bring together different lawyers, but also professors and different people in the government. And so we see that as a form of political participation to the extent that they are sharing their opinions on a variety of issues facing Chinese politics and Chinese government. And so it's a pretty broad definition of participation, but one we think is important.
Okay, thanks very much.
I'm getting some interesting messages in chat. Don, Bill is very much on the same page. He says, Bill, I hope you won't mind me. This is sent directly to me, but he says, it's possible that authoritarian governments from World War I Germany to the CCP today value expertise from outside the state far more than democracies do, which is argumentative and interesting. And Izza saying, maybe not a surprise to the people in this room, but maybe a surprise to the people outside this room, which I agree with.
So let me just add that, I agree with Bill that this is I think I also agree with you guys. This is not an uncommon historical phenomenon or an uncommon contemporary worldwide phenomenon. But the thing is that, up until, 10 years ago, the vast majority of people in the China field thought of the lawyerly profession as something that's exactly as Bill said, moving away from the state, establishing its own center of gravity. And most people thought of legal professionalism as being kind of inherently anathema to state control. So I'm not sure that this point has never been made. It's not true this point has never been made before, but it's certainly not a common perception. Not even now, I think. Just read China law and read the way that people talk about the legal profession. So even if it has been said, it bears repeating and over again from different points of view until it becomes something close to a conventional wisdom, truly, amongst people who actually work on this kind of thing. I think the next in line is Marianne.
All right. Hi. That was an excellent presentation and a very interesting paper, which I had the pleasure to share recently on our little blog. Thank you so much. My question is relating to the Outstanding Lawyer Award. It's more a technical question, probably. I was just wondering whether about these selection procedures for this award and what are the criteria, whether you found out anything more detailed about that. And then also, do these lawyers who receive this award receive any material benefits from it? Are they perhaps in the course of the multiplying red lists that appear in the course of the building of the social credit system, are they perhaps added to red lists and have any benefits from that? Thanks, very brief.
Yeah, thank you. Thank you for the question. The award is devolved to the local level, where they put together a committee, typically made up of bar association people and also officials from the Ministry of Justice that decides basically. And in the documents that we found some documents that kind of outline how they think about it. And I think from the documents we found, they're looking for evidence of involvement with the state. So all the stuff that we're coding for, like involvement in the People's Congress and all that stuff and sometimes they're explicitly looking also for a history of having won smaller awards, like having won local model lawyer awards, and then so that the national award is the capstone on a career or on a period of volunteerism. So that's the process. There's no direct monetary benefit. There is, I'm sure it won't, you will get a banner or plaque to put in your office, and lawyers often display these quite proudly. And as far as I know, it's not linked up with the social credit system in any way.
Thank you.
All right.
I'm also enjoying the discussion about Weber in chat, who I'm reading with students later this week. So yes, Weber is still read.
Of course he should be. Zhang Yang.
So Rachel, thank you very much for the presentation. I want to hear your thoughts about the recent political change and its implication in the so-called new Xi Jinping's era. As we well know, the Chinese reform has created an ambiguous space where domestic civil and foreign organizations can legally operate while being able to navigate political boundaries. However, the recent narrowing of such space and the hardening of the boundaries means that civil society in China will experience increasing anxiety and anger, as you briefly mentioned at the end of your article. That being said, we still find mixed signals. For example, the new environmental protection law, often regarded as very strict, law in Chinese history, facilitated environmental public interest litigation since 2015. For example, in my interview, the leader of Friends of Nature told me that this organization alone had launched 40 environmental public interest lawsuits in more than 10 provinces by August 2018. So again, we are at a point to assess those mixed signals. So I wonder what's your overall interpretation? And is ambiguity and ambivalence still existing in the state and society relations of China? Thank you.
Thank you. Thank you for the question. I've changed my mind a little bit about ambiguity and mixed signals. I had to update my own understanding. I think there's a lot less ambiguity than there used to be. Lawrence and I have another piece where we talk about this a little bit in Law and Social Inquiry. I think that some of the mixed signals have really clarified in recent years, particularly surrounding individual lawyer activism. I think there's just almost no tolerance for it. I'd be interested to hear from you. I don't know whether this is an appropriate space or maybe we can take it offline. I think public interest lawsuits are an interesting space where there still may be some mixed signals. But certainly when it comes to the kinds of actions that taken by individual lawyers, I think it's pretty clear that there's not much tolerance for using extra legal means to try to gin up attention to a case and to an issue, whether it's Weibo or WeChat or any of the many, many things that lawyers were doing in the beginning of the 21st century.
Thank you. Can I make a real quick short comment?
Yeah, I would love to. Yeah, please.
So I think, I myself is comparing contemporary China with Germany in my research. But I think there is some constraint for that comparison, and that should be careful. So to say it's a democracy versus authoritarianism before the World War I is definitely not historical. The ally of England, one of the major allies, Russia, which was a dictatorship, and it was more autocratic than Germany. And England tried to make alliance with Germany by 1903. Okay, so, and they tried to they didn't have war until the World War I. So I don't think the regime naturally was a consideration for the war between them. And also keep in mind, all of those powers are empires. Genocide in Africa, first with England, British Empire, then with German Empire. So this kind of comparison is a historical for historical sociologists. That's my brief comment.
Right. So let's moving further down the queue. So Li Bing, I think, is the next person.
Hi, Rachel.
Hi.
Thank you for the brilliant presentation. And I have one question. You mentioned in your presentation, you asked the question, are the lawyers doing it for money or power? And your answer is no, it's not for either. So my question is, if there were ulterior motivations behind these activities of the lawyers? How are you going to find out? I mean, for those politically shrewd lawyers, model lawyers, they wouldn't probably admit any wrongdoing to their closest friend, let alone a foreign researcher. So how are you going to exclude the possibilities that there might be ulterior motivations behind this? Thank you.
Thank you. Yeah, if I can just add a little nuance to what I said. I think it is money and power. I'm not saying that that doesn't happen. Of course it happens. One mechanism that it happens is that the reputational benefits, many of these lawyers are the head of their law firm. Many of them are founding partners. And so that means that they're often getting a cut of what other lawyers make. So insofar as the reputational benefits of their volunteer work accrue to the entire law firm, of course, there's going to be there's a financial side to that too. And so I think that's absolutely there. And I think it would be a mistake to deny that. I think your question kind of points to one of the things that I think different people could come out differently on in the data. Yes, absolutely. Interview data has its blind spots. One of the blind spots is you hear what people tell you and you don't get to cross-check it against your own observations of their behavior. So we're choosing to take seriously what people told us about social responsibility. And I think a fair pushback would be, do we take it too seriously? I think Isa like this part. I think that she was saying that we give people agency. And I feel comfortable with where we came down on it, but I've also presented this paper in other forums with people who want to push back way harder and really at the end of the day, make it all about money or self-interest or personal benefit. And of course, political embeddedness, having those ties with the state is tremendously helpful in lawyers' practice. It's helpful in protecting lawyers. It's helpful in helping them gather evidence. There's a huge range of benefits that fall broadly within the realm of self-interest, but are professional as opposed to purely financial. We choose to take this rhetoric about social responsibility seriously to make, I think, the basic point that I think it's a human thing that people are looking for meaning in their lives, and we take seriously the idea that this volunteer work is a place where lawyers find meaning, but we are limited, of course, by our methodology and by the type of data that we have.
I totally understand the limitations of doing research work in this area, but I just want to point out the possible duplicity of interviews that you might have with people in this political environment, especially for topics as sensitive as possible corruption, because if you look at those corrupt judges, many of them were anti-corruption heroes, but behind the scenes, they're also taking money for cases. So I think the same rationale probably is also applicable to lawyers, and that is something very important to address in your paper as well, which I believe you have already done so.
Yeah, I mean, to be fair, we didn't even ask about corruption. So that's just a huge and important issue that isn't even in this paper. Lawrence, did you want to come in on this at all? I would have said the interviews were not politically particularly sensitive the way that we went about them. Do you want to speak to that maybe?
Yeah, I think methodologically, we definitely weren't asking, I think, the really important but tough questions that Ling Li is bringing up. And so I think the point is really well taken. I don't have too much to add to what Rachel was saying, except to say that part of what we hope the contribution is that we are at least thinking more broadly about why people might do this kind of work. And we kind of try to, see how often they volunteer. The settings that I interviewed all these folks in, sometimes it was law firms, but it wasn't always the case. And so there were a variety of ways in which the interactions happened and kind of the things we talked about. But yeah, I think the point is well taken. And we definitely don't exclude money and power from the list of possibilities.
Okay, great. Thank you both. Thank you, Taisu.
Thank you. And next in line, I think, is You Ziying.
Professor Rachel Stern, thank you so much for your wonderful presentation. I also have some technical questions about your methodology, especially about interviews. I think in your paper, in your presentation, you mentioned that you observed like 604 lawyers who won the Outstanding Lawyer Awards. So I wonder how many people did you interview? And also how long was the interview and what are the contexts for the interview? And especially among all the people who interviewed, so are there, like how many female lawyers did you interview? Did you notice any gender difference about their perceptions of their roles as state agent lawyers? Thank you so much.
Lawrence, do you want to handle that maybe? You did the vast majority of the interviews.
Definitely. So in terms of the 600 lawyers, so that was a database that we put together. So we didn't talk to all 600, of course. In terms of the interviews, we did 28 interviews. 3 of those interviews were with the same people, so kind of 1 year apart. So we had 25 unique interviewees. In terms of the approach, we had kind of a semi-structured interview approach. So there were a set of questions that we wanted to make sure that we asked each lawyer. And then depending on how the conversation went, we would adapt or adjust or add on to the questions we were planning to ask. Most of the interviews, they always lasted at least 1 hour. Some went for 3 hours. Sometimes there'd be opportunities for kind of follow-up conversations over lunch or over other meals. But for the most part, we were talking to folks in their law firm offices. And that kind of gave a lot of people an opportunity to show off their offices and kind of demonstrate who they were, and they felt very good about being able to talk to a foreign researcher. The question about gender is really good and really important. So we had 3 female interviewees out of the 25 people, out of the 28 interviews. I don't feel comfortable speaking, I guess, more generally about differences between female interviewees and male ones. I think in part because of my positionality. As a male, I didn't feel comfortable always kind of going down that line of questions, though some people did bring up the fact their involvement in the All China Women's Federation, some of the more, the female section of the ACLA, and there were discussions about that that I didn't probe at, especially given the small number of folks who identified as women in this set, but that's something I think can definitely be drawn upon and kind of extended upon in further work.
Yeah. Our only operating assumption about, or our hypothesis about gender is that we suspect that female lawyers are less likely to be invited into informal consultation settings. I think that seems like a pretty fair bet. Since the methodology is coming up, I'll also just share that Lawrence and as we were writing the paper, we thought about it as kind of an old school paper. It feels like kind of, I mean, we have a big database, but then at the end of the day, it's kind of based on about 30 interviews, which is not a huge number. So it feels a little bit like I mean, of course, field work in China is increasingly difficult. So these interviews were conducted a couple of years ago already. But in terms of it feels a little bit like the kind of work that was coming out maybe more commonly in the 1990s and early 2000s.
All right, so Lee, you had a bunch of questions, right? I imagine you must have.
Okay. Thanks, Rachel, and also thanks to the 2 commentators for the wonderful discussion so far. And I think because my second book project is very much actually related to this topic, but for a much earlier period. So my project is focusing on the late imperial period, more or less from the early 17th through the early 20th centuries. But some of the issues actually Rachel and also Lawrence have discussed in the paper are very relevant, especially I have 2 specific, I think, either comments or questions, depending on how we discuss this. One is the article and also the presentation itself, I think it used the term symbolic capital, but without specific citation. So I suppose that term has become quite taken for granted in the field. But that leads me to actually a comment about the notion of power we are discussing here and also in the article. What do we mean by power? It seems to me, I think the focus in the article and presentation is on what we might call bureaucratic power or administrative power, but that is quite, in that sense, that's a conventional notion of power or conception of power. But if we are going to use the term symbolic capital or Pierre Bourdieu's notions of capital power, then I think we probably, it would be very fruitful to go beyond that kind of conventional understanding of power to see how the different kinds of, for example, legal expertise in this particular case can be converted or exchanged for or converted into very different forms of capital, very different forms of power in that sense, if we understand power to be control overall access to valued resources. If that's at least possible, one of the possible understanding of power and also the role of lawyers or legal professionals, either in contemporary China or in historical China, then I think the debate about the tensions between public and private and also state adjacent or completely, we might call private legal professionals might be quite different, at least can take very different directions. Because I think the emphasis on whether they are so much attached to the state or they are very much operating their legal practice independent from the state can create a lot of artificial boundaries which might not necessarily exist in the first place in practice or in reality. Because if a power or capital is so fluid and can be quite readily converted into different forms, then I think those kind of artificially constructed boundaries between the state or non-state realms have to be also re-examined as well. That leads me to the second comment or question. That is, I think, as I mentioned in the chat room, I think Weber's notion, not just Weber, but also many other classical theorists of the state or modern state, apparently based on European experience, have put too much emphasis on, often for them, almost causal relationship between the emergence of what they consider modern or even bureaucracy, and then the kind of liberalization of government power or administration. As I mentioned in the chat room as well, I mean, Imperial China had bureaucracy, no matter how we define it, at least some kind of bureaucracy. Some people have called it incomplete form of bureaucracy, and also bureaucratic expertise almost throughout the Imperial China, without necessarily the kind of modern liberal state emerging at the same time. So the kind of Weberian notion of bureaucracy, especially professionalized bureaucracy or bureaucratic professionalization, as almost one of the major driving force of modern state or modern state formation, and also political liberalization, I think also has to be at least reinterpreted in the comparative perspective, instead of assuming that either there's a professionalization and also professionalized bureaucrats, then we have to assume there has to be some kind of causal relationship between that development and then the kind of political liberalization. When the latter is, at least according to our perspective, is not completely there, we will have to ask questions why and so on. That's kind of, I mean, we have seen this kind of, I guess, methodological dilemma in many other topics and fields. I at least because my focus now is on the kind of emergence of Chinese indigenous legal professionals. I'm very insistent actually on using that just to provoke more thought about why professional or even professional legal professionals cannot be used in earlier Chinese history, which I think is what, I mean, I understand that, all the qualifications of why it has to be used in the kind of modern Euro-American context. But I think just the fact that we kind of feel uncomfortable about using that term in earlier Chinese time period, just because it's the experience and also the kind of trajectory is different. I think that has to be re-examined and also at least subject to very serious debate instead of just as a point of departure. So this might not necessarily be questions specifically for Rachel and also Lawrence, but I think at least that kind of historical perspectives and also comparisons might be helpful and I think if we want to advance the debate beyond just some of the paradigmatic frameworks we often have assumed as almost the kind of normative assumptions before we start any kind of projects focusing on contemporary China. I think I will stop here.
That's a really rich set of comments. Thank you. I was hoping we would hear some historical perspective. I think that there's nothing new under the sun, and I think there's probably echoes of this in the time, or direct echoes of this in the time period you're working on as well. I just wanted to connect some of your comments to, I think, what the direction that Isa was pointing in, her last set of questions about, can we go further? Does state and society always have to be on a linear, like you have to put them on a line together and then you define the middle? Is there another way to think about it? Part of what I heard you saying, and if I got it right, was that that artificial boundary between state and society needs to be broken down still further. I think my colleagues who are sociologists would be more comfortable, with a mutually constitutive relationship between state and society, and would push back pretty hard against this kind of political science linearism that we're kind of pushing in this paper. So I don't know what the answer is, but I'm sure that there are people who this will bother them, how simplistic it is, and they want a much deeper account of the relationship between state and society and the ways in which they mutually influence each other. The other comment I just wanted to make in response to you, Li-Chen, was about I did mention symbolic power, which of course is Bourdieu, but what I'm really interested in how the state participates in constructing people's aspirations. That's the theme that I'm interested in. I'm interested in the cultural aspect of state power. And that's not a Chinese thing at all. Like, of course, all states try to construct values, hierarchy. I think awards play this role in many societies, including American society. Cabinet appointments. There's all kinds of ways in which the state tries to define for its citizens who is valued as the citizens and the kind of what it means to be a citizen and the kinds of aspirations the state wants its citizens to have. So in that sense, that's the notion of cultural power. And I think Isa's comment as well, that in a way, I think another fair critique of the paper is, or maybe it's just, maybe Lawrence is different. I think I'm a little more interested in the state than I am in the society part. So I'm particularly interested in how this cultural dimension of state power, and there's more to be done on the society side for sure, in understanding how professionals intersect with society. The emphasis, I think, on this paper is more on the state. Lawrence, did you want to pick up on any of that? Okay.
Thanks.
So while if anyone else wants to join the queue, please just jump in at any point. We could also have this little chat box debate about labor and so on and so forth actually out in the open. But let me ask a follow-up question, which is, so if I want to rationalize the literature that basically tends to posit expertise as being kind of like in opposition from state control, the characterization would be something of the following, all right? So like expertise, including legal expertise, but perhaps like more purely, scientific expertise, it involves a certain kind of like internalist point of view, where the fact that you're an expert on a certain field and you're seeing it always from, or most readily from, the insider point of view, means that you have a tendency to kind of like not ignore, but at least like resist, or in some cases intellectually marginalize outside influences that aren't folded within your field of expertise in its own language in a very easy fashion, right? So this would be the reason why people have often believed that, like when the legal profession gets going in terms of professionalization and so on and so forth, it's inevitably going to develop this like state independent streak, because the state can't keep up with all the things that are going on within the legal profession. And therefore, lots of the external demands the state makes of the legal profession will not be properly internalized, or into the language of the profession itself. I actually perhaps the better way to put it is that the state has too many external demands for them to all to be expressed in legally internalistic language at a sufficiently rapid pace. And hence, at some point, if you're basically doing the bidding of the state's requests are going to seem anathema to this internalist language that you usually enmesh yourself in. So that kind of begs the question to you guys, which is, you know, like if a lawyer becomes really strongly state adjacent, have any of your interviewees ever expressed a certain kind of like professional schizophrenia on his various roles, seen a conflict between his role serving the state and his role serving the ideals of the legal profession? Like, so like I should like my personal view is I suspect the answer is no, given that, you know, like whether there's always that like speed gap in translation depends very much on the nature of the legal system. And in the Chinese case, I don't perceive that, especially recently, I don't perceive too much of a speed gap whatsoever. And so I think that there's a large potential for relatively seamless coexistence of these two identities. But if I were basically like playing devil's advocate and channeling my internal kind of like 1990s or early 2000s liberal, like legal professional idealist, that's kind of what I would say. To raise some kind of like suspicion or skepticism on whether states and lawyers can actually coexist in this fashion.
Yeah. Am I on mute? No. Okay, good. I guess my starting point is a little different, but I end up in the same place as your question, Taisu. I think the idea that lawyers will be independent of the state is one of the great myths of the American legal system, right up there with the idea that litigation can happen through social change and social change can happen through litigation. Sorry, I reversed the causal error there. But it's one of the things that the American legal profession loves to believe about itself. And the extent to which it's empirically true is a different thing. But I think we've taken this myth that's at the center of our own identity about our own legal system and tended to export it or look for examples of it in other contexts. So I want to hear what Lawrence has to say as well. But no, I don't see any role conflict in Chinese lawyers in general. And to serve the state and to serve the legal profession, you can do those things simultaneously. And that's, I mean, again, I'm going to channel my students, my JD students. It's enviable, how wonderful that you can do all these things at once and not experience the divided self and the kind of tensions that sometimes comes along with part of being an American lawyer. What do you think, Lawrence? Did you see role conflict?
Yeah. So in terms of the interviews themselves, I think what Rachel said and what Taisu was getting at was what we saw. A lot of people did not see inconsistency in their ability to kind of serve clients and serve the state. And I wanted to plug John Bliss's new LSI piece again, which also kind of looks at a different set of lawyers, kind of their role conception. At least, I mean, we had a limited number of interviews. I mean, there's one example of someone who over time decided that serving the state wasn't useful, at least in terms of he wasn't getting the results that he had expected to see. And so there was some disillusionment over time. And so maybe we would see over the course of a career, people, of course, kind of move in and out and have different views of their role and who they are. And that might be something that's worth looking at comparatively. But in terms of when we talk to folks at those moments, this idea that you could do both service to the state and serve one's clients and be a good lawyer in terms of the professional, or what we might think in the US as kind of a good professional lawyer, didn't seem to come into conflict at all.
Yeah, so that's exactly what I would expect given my personal priors. I would say though, it's not an exclusively American myth. In the sense, like you think about like what are the earlier forms of this myth? Like probably one of the most prominent is like Nicholas Luhmann and his ideas of like systems theories applying to the legal profession as like a self-contained internalist system. And he got that mainly by observing German lawyers in the pre-war period. To some extent, like I think right now, the German legal profession buys into this myth at the current moment even more strongly than the Americans. Like they think the Americans are like realist hippies, whereas like they are the more kind of like internalist, doctrinalist people who are principled in their adherence and protection of like idealist, legal, professional ideal types, basically. Nonetheless, so Mercedes.
A couple of, I mean, I basically, I have a little, perhaps because my background is more in politics and anthropology, and so I have a different taking of things. So I'm thinking about how long do you know the interviewees, whether you have met them before, had some interaction before, or you just did the interviews and that's it. That's all. Because the interviewees, for what I have here, they were elite members of the profession, and I wondered the answers had to be suited to the position, and maybe they were saying what they wanted you to know, and they were portraying themselves and the work in the way they thought it should be portrayed to foreign researchers. So I'm talking about the difference between kind of a more anthropological kind of analysis in which people expend longer time doing this field work in order to understand or get the keys of how people deal with their own selves, their own profession, the networks of power, ideas of a status, and so on. So, you know, and also there is another thing I have a little problem about is that, I mean, we Western, I mean, I'm Western as well, but we have probably a more dichotomic view of how the world functions, this idea of state and society. When in other parts of the world, especially in East Asia, there is don't exist those sharp dichotomies, for what I know. And it's not a dualist world. It's quite different. So I have that, I think probably maybe we export our own frames of mind when we analyze other places of the world. And then sometimes I just saw that I had a big problem with those things, yes. So the answer is maybe we cannot take them at face value. Right? Yeah, so that's it. Thank you.
Much for the question, Mercedes, especially related to methods. So maybe I'll speak to that point. So I think as Rachel was getting at earlier, that's definitely a fair critique. We did make the choice to take what these lawyers told us seriously, and based on the kinds of interactions we had with them in the meetings, kind of to confirm that. In terms of how we found these folks, it wasn't the case that we knew these people ahead of time and we kind of kept talking to them and so on and so forth. There was a lot of cold calling, a lot of cold emailing, recommendations from previous interviewees to other interviewees. There were a number of folks we talked to multiple times across different years. So there is that aspect of it, but it's certainly not an ethnographic or an anthropologically rich study in that regard. So there is that limitation. I would say, you know, to the extent we were able to have more informal conversations with these folks outside of the formal interview setting, I think that helped, at least speaking for myself, helped confirm some of the things that we heard in the more formal institutional setting. But that is certainly a fair critique. I think we would just suggest that the way they do portray themselves or the way they do talk about themselves certainly matters. So even if there is some duplicity there, even if there are certain things that they told us because they wanted us to hear them, we thought, at least for the purposes of this paper, that that was still worth reporting on and kind of including. Though yes, I at least would certainly welcome folks who are embedded in these spaces, who are spending a lot more time with these folks, who are actually part of those communities, to kind of speak more about it. And hopefully this opens up chances to do that. But the critique is well taken.
Yeah, I agree with that. That was well put, Lawrence.
All right, great. So I think we've kind of come to the end of our 2 hours here. So everyone, please join me in thanking Rachel, Lawrence, Bill, and Isa for a fantastic session, and also an unusually lively chat box conversations. Like, so to everyone who has basically contributed to that, thank you as well. So I will look forward to seeing perhaps many of you guys next month on April 23rd for the next installments, which is again Li Chen talking about legal professionals in the late imperial context. All right. So until then, enjoy the onset of spring, especially on the East Coast, and have a good weekend.